The court is in session in the trial of prosecutor versus Ms. K. Lugumo. Counsel, you may proceed.
Your Excellencies, if I have the court's permission, may I proceed? Thank you. I am Mooter 1 for the team representing the prosecution in the case before the Honorable Court today. Your Excellencies, over the course of the next 20 minutes, myself and my co-mooter will be addressing the two charges against the defendant, Ms. K. Lugumo, before the Honorable Bench. First of all, there is the charge of the crime against humanity of extermination under Article 7(1)(b) of the Rome Statute of the International Criminal Court. Second of all, there is the charge of the crime of the war crime, willful killing, under Article 8(2)(a)(1) of the same, as being presented to Your Excellencies. Your Excellencies, my submissions to this court in respect of the crime against humanity of extermination, as highlighted under the elements of crimes document of Article 7(1)(b) are the following. First of all, the perpetrator, Ms. K. Lugumo, killed one or more persons either directly or indirectly by the infliction of conditions of life, which include deprivation of food, water, and medicine. Secondly, those killings were mass killings and were committed as a part of an attack. Thirdly, that attack was directed against a civilian population and was calculated to bring about a destruction of a part of that population. Fourthly, that attack was also widespread, or alternatively, it was systematic. And lastly, the perpetrator, that is Ms. K. Lugumo, intended the killings, or alternatively, knew of their commission and failed to take any reasonable steps to prevent their occurrence. Your Excellencies, before beginning my submissions, I would like to highlight to this Honorable Court that the issue of accountability of heads of states is what is presented to the Court today. The issue is of a head of state who must be held accountable for her actions, either her positive steps, her positive actions, which caused the death of numerous unidentified people, 147 people during the required time period killed, along with unidentified further numbers. Either, Your Excellencies, through her positive acts or through her failure to take any steps to prevent these killings from happening, despite the fact that her position was a position of responsibility that she had taken upon herself, that she had been democratically elected as president, the people had trusted her in order to bring peace and stability back to the country, she had failed to do so. And Your Excellencies, if the court holds that she did not cause the killings through positive acts, it will be humbly submitted that her omissions on her part, despite her duty towards the people, was also suffice for the accuracy of the crime. If I may proceed with my submissions, Your Excellencies. I would like to emphasize that in the required time period, there were 5 incidents of killing which took place, the mass killings which I will be emphasizing. First of all, the killing of 120 demonstrators on the 22nd of June of 2010. Second of all, the death of 6 prison detainees due to lack of food and water in prisons. Third of all, the mass killing of opposition party members and supporters who were allegedly buried in mass graves. Fourth of all, the alleged abduction and killing of Mr. Durman and his family members, as well as many other PFP activists, supporters, and members. And last of all, the killing of 16 PFP members whose photographs of their bodies were found, bullet-ridden bodies were found, and these were the 5 incidents that Ms. K. Lugumo either caused directly through positive acts or failed to prevent from occurring. Your Excellencies, why does the perpetrator incur criminal liability for these crimes? It is humbly submitted that the reason her liability for these crimes stems from the fact that under the law, as highlighted in the case of Prosecutor versus Jokic, which is on page 13 of the submitted memorials, under the law, the perpetrator's criminal responsibility stems from the fact that her conduct must form merely a link in the overall chain of causation and does not necessarily have to be a direct cause or a but-for cause of the death. In other words, it does not have to be proved by this court that but for the actions or the omissions of Ms. K. Lugumo, the killings would not have taken place, but instead, did the conduct of Ms. K. Lugumo form a link in the overall chain of causation which led to the deaths of the people just mentioned? Your Excellencies, Since her conduct must only form a link in the overall chain of causation, it is submitted that she might either be held individually criminally responsible for the incidents of killings, or she might be held jointly criminally responsible. First of all, why individual criminal responsibility? This is because, Your Excellencies, the actus reus of the crime, as stated, is that of killing. Killing means to cause death, as referred to under the footnote to Article 6A1 of the Elements of Crimes document. Now, the question is, do omissions or failures to act on the part of the perpetrator qualify as satisfying the criteria for the actus reus of this crime? And in answer to that, I would like to humbly submit that, as stated on page 13 of the memorials, in the case of Prosecutor versus Jokic, as just referred to, the omissions do in fact qualify as fulfilling the actus reus of the crime. Therefore, Ms. K. Legumo's failure to ensure that food supply in the prisons was increased along proportionately to the increase of the prison detainees in the prisons, this failure on her part does qualify as actus reus for the killing. Secondly, her failure to prevent the security guards from indiscriminately shooting on a group of protesters who are armed, but albeit just armed with stones. Her failure to prevent this indiscriminate firing also counts for individual criminal responsibility. And Your Excellencies, I would humbly submit the reason for this is through the doctrine of command responsibility. This doctrine, Your Excellencies, holds that in the case where a superior-subordinate relationship is established, and along with that, the accused or the perpetrator in this case knew or had reason to know that the crime would take place or has already taken place, and following which the perpetrator failed to take any form of reasonable step to prevent the killings from taking place or to prevent further killings from taking place. Your Excellencies, this is the doctrine of command responsibility, and it is under this doctrine which it is humbly submitted that the defendant should be held liable. Your Excellencies, further on, within the same doctrine, the Ms. K. Legumo, the perpetrator's position as the head of state, and not just as the head of state, but as the head of both executive and military branches of state, due to the fact that she has taken over all powers due to emergency provisions after postponing elections. The fact that she has taken on all powers for herself means that she turned from a political leader into a political leader with the power to make military orders as well, due to the emerging provisions in the Constitution. So, her de facto position, while alone suffices to incur criminal liability under the case of Prosecutor versus Delalich on page 15 of the submitted memorials. So, her de facto position, along with the fact that there was actual knowledge, the so-called actual knowledge, Your Excellencies, occurred due to the reporting of not only Human Rights Call, which was a reliable source, but also through the reporting of foreign media. This actual knowledge, coupled with her de facto position, coupled with the fact that she made a statement in a press conference specifically stating that although she found Rightist Wing not to be committing any illegal activities, that if she did, she would take reasonable steps, meaning that she put herself in a position, she took the responsibility upon herself that if she came to know of Rightist Wing committing any illegal activities, she would take steps to prevent it from happening. However, in the event that she had the knowledge and she had the position in the government and the authority to take any steps against Rightist Wing, she failed to do so.
How would you prove that she had the knowledge about the violence acts being taken by her subordinates?
By her subordinates? Your Excellencies, what this council is humbly contending is that due to the fact that when a head of state takes over powers under emergency provisions of a constitution for the time period that the emergency powers are in existence, for that time period, political leaders turn from political leaders into total leaders for both the executive and military branches. And not just that, Your Excellencies, if that does not suffice, it would be impossible for Ms. Legumo to contend that she did not know about the killings simply because of the widespread nature of the attack and the fact that there were 127 people killed, 120 people killed on one day alone. And there was major reporting by reliable sources like Human Rights Call and by foreign media, who contended that it was Rightist Wing who was responsible for the acts. It thus becomes impossible for the perpetrator to contend that she had no knowledge of the acts.
Thank you.
After the incident, did the head of the state took any action against the law enforcing agencies? Was any inquiry ordered or not?
Your Excellencies, no, there is no evidence in the fact that she took any steps to take any form of action against law enforcement agencies. And this is despite the fact that while it may be contended that the law enforcement agencies, that is the security forces, acted in self-defense by shooting on the crowd, this is not a limb that can be sufficed under Article 31D of the Rome Statute, because this, in order to plead self-defense, the action taken by the perpetrator must be both reasonable and proportionate to the danger which is being posed. In this case, there was a group of civilians who had come out on the streets, and they were armed with nothing but stones. And there is no evidence that they were prepared from before to make a violent step. It was only after the security forces came that these people took the step of picking up the stone. Your Excellencies?
Thank you.
Thank you. If I may continue, the second way Ms. K. Legumo may be held liable is through joint criminal responsibility. That is, she may be held to be aiding and abetting the killings through the fact that she omitted to take any action, as I've already emphasized, against the perpetrating party, that is righteous wing. This failure to take any form of action, not even a reprimand, as there's no evidence to suggest even a reprimand on her part. Complete failure to take action on her part means that she was tacitly facilitating or approving these killings that were taking place, and apparently found no reason even to take the smallest of steps to ensure that maybe some protection may be offered to the targeted population, as I will contend later is the population of opposition party members and supporters. Further, Your Excellencies, the next element of the crime is whether it can be said that the killings were mass killings for the purposes of the elements of the crime. And did these mass killings occur during the commission of an attack? First of all, Your Excellencies, were the killings mass killings? Indeed, they were. It is not for this humble council or for any other council to state that 147 people in a period of not even 2 months, 147 deaths, indiscriminate deaths, may not be held as mass killings. And even further, Your Excellencies, this was just the confirmed number. There is no evidence, there is no direct evidence to suggest how many more people were killed. And in fact, Human Rights Call even alleged that there were mass graves being dug where the bodies of the PFP members, activists, and supporters were being buried, and there was absolutely no indication that Ms. K. Legumo took any notice of any of these incidents.
Could the court just ask you to draw our attention to at which point of law do you learn that mass killings is a requirement of the crime against humanity? I read from Article 7, crime against humanity means any of the following acts committed when part of a widespread or systematic attack against the civilian population with knowledge of the attack. What's missing is any mention of mass killings.
Your Excellency, I'm sorry, I'll clarify. I was referring to the Elements of Crimes UN document under Article 7(1)(b). The Elements of Crime document is a reference document for courts and provides a detailed list of the elements of crimes that must be fulfilled in order for the act to take place. Thank you. Further on, Your Excellencies, was this attack, was this course of conduct directed against a civilian population? And further, was it calculated to bring about a destruction of that population? Both these aspects of directed and calculated imply some form of targeting on the part of the government. Was there a targeting of a population? Indeed, Your Excellencies, there was. It could not be a coincidence that 147 people, identified people, plus numerous unidentified numbers would all be members of PFP activists and supporters. That could not possibly be a coincidence. And furthermore, Your Excellencies, what highlights this is that from the very beginning, when Ms. K. Legumo was made president and when she took over emergency powers, she made it her goal. She made it her goal, in fact, to ensure that all form of dissent was suppressed. No form of dissent was allowed from the very beginning. And Your Excellency, this is a policy that may be seen continued through the mass killings that were taking place. And all mass killings were directed against the population, the target population, that is, the members of opposition party members, supporters, and activists. Further, Your Excellencies, was this targeted population a civilian population? This, Your Excellencies, brings us to a realm of the law where there's a distinction being made between civilians and civilians who are armed or combatants. Your Excellencies, in this case, it is contended that under Article 50, subsection 3 of the Additional Protocol 1 to the Geneva Conventions 1977, The presence of non-civilian elements in a population does not deprive the population of its civilian status. Your Excellencies, what I'm humbly submitting to the court is that it cannot be contended by the defense or by the defendant that just because there were certain members of the PFP members, activists and supporters who were resorting to violence, who were resorting to direct participation in hostilities in order to overturn the government, just because there were some members who maybe did not qualify as civilians under the purposes of the law, that does not deprive the overall population of its civilian characteristic. And this, Your Excellencies, under Article 50, subsection 3 of the additional protocol, which is presented to the court. Further, Your Excellencies, even if Your Excellencies do consider that, in fact, that this may be overturned in some cases, alternatively, the court may hold, as has been held in previous cases, that demonstrators did not lose their status as civilians despite their direct participation in hostilities, because it has been held that members of a resistance movement do not lose their status as civilians, do not lose their immunity from violence under the law, and do not qualify as combatants despite the fact that they may, in fact, take a direct participation in hostilities. This, Your Excellencies, I would refer you, please, to page 18 of the submitted memorials, where the following cases are cited: Prosecutor versus Tajik, Prosecutor versus Kupreskik, and the case of Babi, which is highlighted in Prosecutor versus Blaschik. All of these cases held that members of a resistance movement do not lose their status as civilians. They retain the status as civilians, and therefore the demonstrators on 22nd June who were on the streets, who were throwing stones, did not lose their status as civilians, and therefore, in fact, the targeted population was a civilian population. Further, Your Excellency.
Could we just clarify this point? A member of a resistance movement who is engaging in hostilities, who is, as we say, directly participating in hostilities,
yes,
can or cannot be targeted, killed, by the opposing party to the armed conflict?
Your Excellencies, I'm submitting, I repeat, I would like to submit that members of resistance movement do not lose their status as civilians. That is, they do not become combatants under the law just because of their participation in that particular resistance movement. In this case, the 120 demonstrators were resisting the repressive government of Ms. K. Legumo, who had been denying them elections, who had made no difference to the issue of price hikes, who had made no difference to the fears of the population, though she had promised she would do so. And to top it all off, there were these indiscriminate killings, and there was absolutely no aim on her part, or no indication that she had any aim.
I agree absolutely that their mere membership in the group does not deprive them of their ability or their status as civilians. But you also agree with me, I'm sure, that were they to directly participate in hostilities, they would still be technically civilians, but they would lose their protection. Do we agree?
Your Excellency, I'm sorry, I don't seem to be making my point very clear. What I would like to contend is that no. When they take a direct participation in hostilities, if they are A, members of a resistance movement, and then B, as a part of the members of that group, take a direct participation in hostilities, do not lose their immunity from violence under the law. Did that help your Excellency?
Perhaps we should just consider an example, a real-world example. Would a member, it becomes a bit tricky, would we consider, say, the LTTE for the 27-year struggle in Sri Lanka to amount to a resistance movement? And my question is, if they participate in hostilities, can they be targeted? It seems that you're saying no.
No. Your Excellencies, if they are taking part in a resistance movement, they cannot be targeted because they still qualify as civilians.
Okay, all right,
Yeah.
Let's move on, shall we? Thank you.
Thank you.
They were protesting against only the price hike
No,
early
Your
elections,
Excellencies.
and the elections only.
Yes, these protesters were protesting against the oppressive government because they had been denied elections, they had been denied the relief from price hikes, and there was a continuous policy of repression and of oppression and of suppressing any form of opposition. There was no one allowed a voice in the government. There was a dictatorial regime going on, and because of that, Your Excellencies, the protesters had the right to come out on the streets and call for the Legumo government to withdraw. However, instead of that, they were indiscriminately shot on, and 120 civilians were shot. Thank you. Your Excellencies, To sum up, I would like to say the last point is whether these...
And they were
Yes.
they were of the same nationality as of the president.
I'm sorry?
They were the same, they were national of Batavia.
Yes, yes. The civilians were
protesters,
nationals of
the
Batavia.
civilians.
Yes, the civilians were nationals of Batavia. Lastly, Your Excellencies, did these killings qualify as an attack? And was that attack either widespread or alternatively, was it a systematic attack? First of all, Your Excellencies, what is an attack? As emphasized before, an attack is a course of conduct and it involves the multiple commission of crimes against humanity. In this case, the crime against humanity is that of extermination. Were there multiple killings? Yes, there were. Were there multiple victims in each incident of multiple killings? Yes, there were. Were these killings mass killings? Yes, Your Excellencies, they were. Now, was this attack, was this course of conduct on the part of the government a widespread attack? Your Excellencies, it is humbly submitted it was. In the case of Prosecutor versus Tajik, on page 18 of the submitted memorials, this case states that the term widespread refers to the large scale of the attack and the number of victims, whereas the term systematic refers to the organized nature of the overall attack and not individual acts. In this case, Your Excellencies, it is humbly submitted that while it may be contended that the individual attacks were not systematic in that they were isolated, it may not be contended that the overall attack was not systematic, as is proved by its targeting of a civilian population. Your Excellencies, if you have no further questions, I would invite my co-counsel to come up. Thank you.
May it please the court, I'm Moot 2 from Team 6, pleading on behalf of the prosecution. Your Excellencies, over the course of the next few minutes, I would demonstrate to the court that Biscay Legumo is liable for the charge of willful killing. If it so pleases Your Excellencies, I would like to begin my submissions now. My first contention is that the situation in Ratavia qualified as an armed conflict. Furthermore, this armed conflict was international in nature. My second contention, Your Excellencies, is that the victims were protected persons under Articles 4 and 5 of the 4th Geneva Convention. Thirdly, Ms. K. Legumo was individually criminally responsible for the killings because she ordered the killings and because she was the de facto leader of the Ratavian forces. Now, moving on to my first argument, Your Excellencies, the situation in Ratavia was an armed conflict. Kindly refer to page 22 of the prosecution memorial. The ICTY Appeals Chamber judgment of Tajik has held that an armed conflict exists whenever there is a resort to protracted armed violence between governmental authorities and organized armed groups. This entails that the violence in the situation must last for a long and a continuous period of time, and that the groups involved must be organized. Armed youth started attacking attacking government property and officials from May 2008 onwards. Furthermore, they intensified the struggle from August 2010. The organization of the SIL forces can also be inferred from the fact that they were strong and independent enough to form an ad hoc governance committee. Furthermore, SIL formed several armed groups across Pala who were in possession of weapons manufactured in Igania for use by Iganian armed forces. Moreover, Your Excellencies, the armed conflict in Ratavia was international in nature. The armed conflict was a proxy war fought on behalf of the SIL forces against Ratavia. Your Excellencies, Tajik has laid down the overall control test for determining whether an alleged controlling state does indeed exert control over the forces in question. Excellencies, kindly refer to page 24. It was held in Dalalaj that the overall control test could be satisfied even if the armed forces acting on behalf of the controlling state had autonomous choices of means and tactics, although participating in a common strategy along with the controlling state. Your Excellencies, a number of factors indicate that Igania did provide assistance to the SIL forces in the planning of its military activities. The weapons that were seized on the night of the 20th of August were Iganian manufactured weapons that were used by Iganian armed forces. Furthermore, SIL expressed solidarity with the PFP in its anti-government movement, which was openly backed by the state of Igania. Moving on to my second argument, Your Excellencies, the victims, the 164 victims were protected persons under the 4th Geneva Convention. Kindly refer to page 27 of the prosecution memorial. Article 4 of the 5th Geneva Convention states that persons protected by the Convention are those who at a given moment and in any manner whatsoever find themselves in case of a conflict or occupation in the hands of a party to the conflict or occupying power of which they are not nationals. Since it has been contended that a proxy war existed in Egania, in Ratavia, the MIL as de facto organs of Egania were not nationals of Ratavia. Therefore, they did not have the same nationality as the Ratavian forces, by virtue of which they were not protected persons under Article 4 of the 4th Geneva Convention. Furthermore, Ms. Legumo was aware of this protected status because it was evident that they were an adverse party to the conflict, as they had pledged support to the PFP and Egania against the Ratavian government.
Excuse me.
Yes.
As the audience are aware, we've discussed a number of times, this court has considered the issue of the nationality of the protected persons. For me, I don't think we've quite resolved this issue well enough yet.
We haven't.
But you add another element now, when the contention is that they're arguably not protected persons because they are not national, or they're not of a country other than Ratavia. Let me say that again. They are of Ratavia. They are nationals of the one country.
Yes, Your Excellencies. They were, in fact, of the same nationality as the Ratavian forces. They were not de facto organs of Egania because a proxy war did not exist.
Okay, so as a result, they were the same nationality as the Ratavian government.
Therefore, the Article 4 is not applicable because they were not protected persons.
They were not protected persons.
Yes.
Okay, thank you.
Are you clear on that?
Yes, I'm clear on that.
I'm so sorry that I was not able to address that question in time. Sorry. Moving on. Your Excellencies, my third contention is that Ms. K. Legumo is individually criminally responsible for the killings because she ordered them. Kindly refer to page 25 of the prosecution memorial. In Prosecutor versus Dario Cordict, it was held that no superior-subordinate relationship is required for finding of ordering so long as it is demonstrated that the accused possessed the authority to order. Your Excellencies, Ms. K. Legumo was responsible for the administration of Ratavia because she was in control of all aspects of governance from the top to the lowest level of administration. Therefore, she had the authority to order, and by virtue of which she is responsible for the killing of 164 persons. Furthermore, in a press release on the 20th, can I have 30 seconds to conclude my argument? I took a few seconds. Furthermore, in a press release on the 20th of August, Ms. K. Legumo openly declared that she would counter the violence perpetrated by the SIL forces with equal force. This means that she had intended on reacting in a violent manner to the actions of the SIL forces. In light of the foregoing, Your Excellencies, I submit that K. Legumo is individually criminally responsible for the killings of 164 protected persons in the context of an international armed conflict. Unless you have further questions to ask, I rest my case.
Defense Counsel, you may proceed now.
If it may please the court, may I proceed? I am going to be the opening counsel for the accused in this case, prosecutor versus Ms. K. Legumo, while my co-counsel will be pleading rest of the case. I would like the honorable court, if they allow me, to remind the court briefly with the facts. Thank you very much. Your Excellencies, Ms. K. Legumo became the president of Ratavia in 1990 and remained the president for 2 decades until 2010 after the onset of emergency and political turmoil. Opposition parties led by PFP called a nationwide strike on 1st April 2010 against the government affecting normal life across Ratavia. Large number of unstable, potentially violent crowds were asked to gather in heavily populated areas which the government stopped for general safety for the people. On 11th May 2010, discussions were held by PFP with Igania and Sarko, who promised to support in its aim of overthrowing the government, which was this thing was announced by Mr. Hotman, spokesperson of PFP, subsequently to which he was arrested for the crime of sedition on 10th June 2010. On 22nd of June 2010, prosecutors numbering around 1,500 stoned security forces, which led to response by the security forces, resulting in the deaths of 120 demonstrators and subsequently arrested over 6,000 protesters. Furthermore, Mr. Mikomo was associated with the formation of an armed group called Righteous Wing, which was alleged for abducting and killing for bringing peace to Rotavia. Ms. K. Ligom, when asked, had stated the organization was an apolitical group, doing nothing illegally for the best of our knowledge. Meanwhile, 6 deaths of PFP detainees occurred while in the prison due to the scuffle between the prisoners and the prison guards. Furthermore, Your Excellency, on 15th of July 2010, it was reported that many detainees were missing, and it was speculated that they had been buried in mass graves, after which Babylon Times Daily published photographs of 16 bodies of PFP cadres found on the outskirts of Babylon. On 25th March 2008, a group by the name of SIL was formed, which aimed at using all means possible to break away the province of Spala from Tavia. From 30th of May 2010 to 30th of August 2010, armed groups from SIL deliberately targeted government properties. On the night of 20th August 2010, security forces were conducting standard search operations and faced firing, while resulted in the death of 3 security personnel. In the response to the threat, 11 people died. The most important fact is, on 25th of August 2010, in search for SIL members, security forces went into a locality of Paradise City, where they found a large crowd, which they dispersed using non-lethal methods, even after they were being attacked by the bomb. This is a major point in the facts. The forces approached the SIL office nearby, where a bullet was fired at them. The troops surrounded the building and started retaliating towards it, which resulted in the death of 153 people. After stating the facts, I will call upon my co-counsel to proceed with the pleadings. Thank you.
Good evening, Your Excellencies. I am the co-counsel for the defense of Ms. K. Legumu in the case of the prosecutor versus Ms. K. Legumu. I will be starting with the issues. There are 2 issues before this court. The first one being that determining whether the accused Ms. K. Legumu is innocent or guilty on the charge of crime against humanity of extermination, as stated in Article 7(1)b of the Rome Statute for alleged acts committed in and around Babylon City from the 27th of April 2010 to the 15th of July 2010. Secondly, in determining whether the accused Ms. K. Legumu is liable for the charge of war crime of willful killing under Articles 8 to A1 of the Rome Statute for acts committed in and around Paradise City from 20th of August 2010 to the 25th of August 2010. The first charge against the defendant is that of crimes against humanity of extermination. As for individual criminal liability to be proved or established, the first thing that is required is to prove that there was an actus reus, that Ms. K. Legumu did in fact order directly or indirectly, whether expressed or written or in any other form, induced the actions of the forces that ended up in the deaths of the 120 protesters in that incident. Now, commission refers to the participation of an accused in the actual events which constitute the material elements of the offense in question. Article 25, 3b establishes individual criminal responsibility for persons who give orders to commit the crimes in question, as was stated in the prosecutor versus Akayesu. In this event,
if I could just clarify, I believe the prosecution's argument was premised on Article 28, a new or should have known argument. Will you address that in a minute after you've addressed Article 25?
I would go in my own procedure, my own procedural way, so I can make my way towards that after I clarify the first charge.
Okay. As long as you intend to address it. Then
I will come to the responsibilities, individual and superior's responsibilities in a minute.
But you must answer the question posed by the court first. You see, you can't just
Your Honor,
answering the question.
Your Honor, I will answer it, but in a minute, once I get to that part, if I may, please. Secondly, since there was no direct or indirect order or inducement on the part of the defense, the second charge that the prosecution completely failed to prove was that of mens rea. What would have caused Ms. Kelugumu to want to kill people in the first place? Now, the mental element for instigation requires that the accused wanted to either provoke or induce the commission of the crime in question, and she was aware of the eventual likelihood of the event occurring. As a result of her conduct, as was seen in the prosecution versus Tihomir Blasic, the instigator was not liable for the excess of the person who acted at his instigation, as was dictated by Gerald Verhulst in his joint criminal enterprise. So even if in the extreme possibility that she did do a mens rea, she would only be liable to the point of where her inducement finishes and then excesses on the part of the perpetrator who did the action start. Furthermore,
but you do admit that she should be responsible for the acts of her subordinates. It's another story whether they were committed or they were not committed.
Your Honor, I did not understand the question.
Being a head of the state and the president, she is responsible for the violent acts of her subordinates.
Your Honor, in the event her subordinates do actions which are illegal, she would be responsible.
Yeah.
In the event that they could do acts that are illegal, but the validity of whether they do that in the first place is in question. Furthermore, the element requirement of ordering is not present. That is, say, of the ICC, ordering requires that the person giving the order must have the mens rea. In the present case, Ms. Kelugumu nowhere specifically ordered the killing of individuals. Thus, she cannot be held criminally liable. Because understanding that all forces work under a chain of command, unless there is an order, no person in that chain of command is allowed to act of his own free will. In the event that he does, he is breaking that chain of command. And Ms. Kelugumu, being the president of the state, is at the top of that chain of command. If there has been a breach, this should be against any order that she had placed. So she needs to order so it travels down the chain of command and actually results in an action. Furthermore, there is an absolute absence of evidence. Now, the court may take facts into consideration which are public knowledge only if they are from more than one public source, as was seen in Nicaragua versus the US of A. You cannot have a single source dictating all the facts. That has so much doubt in it that it completely puts the charges in ambiguity. Furthermore, in the Democratic Republic of Congo versus Uganda, the court did not find evidence of news reports weighty and convincing. The party having the burden of proof, that is the prosecution, must not only bring evidence into support of their allegations, but must also convince the court as to the truth of those allegations. The Babylon Times Daily is one news source with no credibility. It may be a political factor by the opposition, as people who remember history would know, and stated in Michael Carmichael's Propaganda and the Politics of Perception, Adolf Hitler had a ministry for propaganda that he used long before, when he wasn't even in politics, when he had started his political campaigns. He had a friend working his propaganda. So it is a major political tool. Propaganda is one of the major political tools at the disposal of every politician. Furthermore, now coming to the point that the Honorable Judge asked, failure to prove liability under the doctrine of superior responsibility, also called the Yamashita Standard and the Medina Standard, the standard for culpability of a civilian leader lies that there was conscious disregard of information, which was stated in Article 21(8)(b), which entails stringent requirements in the terms of information available to the accused in the first place, which is the civilian superior in this. In contrast to a military doctrine, where, owing to the circumstances of the time, should have known comes into play. But the question is, was there a military confrontation here that she ought to have known, or was there a simple normal, routine action that was supposedly in action. But
excuse me, sir, I'll ask you to proceed, but I think the question more specifically is not what the situation is, but whether she herself is a military commander, because military commanders also exist in peacetime. Military commanders exist regardless of the situation. So if I could really direct you specifically to the question of whether she was, regardless of the situation, or was not a military commander.
In answer to Your Excellency's question, firstly, there is always the Chief of the Army Staff, who is the de facto leader of the military. He reports to the President. Only in times of war does the President take total control, including that of military matters, into her own hands. Unless and until there is a war in progress, a declared war or an attack on the state, the President leaves the decisions and all the major...
Could I contend that in addition to the situation of war that you suggest when the President takes complete control of the military, that on the facts before us, Ms. Lagomu has taken significant amount of control of all of the administration, presumably including military, following, amongst other things, the natural disaster and the declaration of emergency?
In answer to that, Your Honour, Ms. K. Lagomu did take a lot of matters into her own hands into consideration when she required and brought them to the table. But in that mannerism, what we need to understand is a military action requires the military to be there. These were security forces personnel who were there under the military doctrine that would only come into effect when and if the situation moves from a simple confrontation between protesters and security forces to that of a military armed conflict. Now, in response to this, she is the de facto military head as well. The Chief of the Staff does report to her. But until there are actual situations in where armed conflict comes in and the military needs to take serious actions, she will not be answering every single question that is posed within the military and the ranks.
Okay, thank you. Would you like to proceed in accordance with the time? Thank you.
There was no conscious disregard of information, thus, by Ms. K. Lagomu. Hence, no liability can be attracted under Article 28, 1B of the ICC statute, since the requirement is not complete. Furthermore, the security forces present at the demonstration acted in self-defense. We accept the fact that there were 1,500 people stoning them, and the response did end up with 120 dead. But if you look at the facts, you would see that this was a response. This was retaliation to an attack. Initially, if you look back at the facts, you would see that the protesters had not been violent in the previous protest that was of the 29th of April 2010. They were not violent. As a result, there was no precedent for them to come with riot gear to be prepared for a riot, because the last protest was 50,000 people in the Babylon city. There was no rioting, so they were not prepared for a riot. They were simply there for riot control. Thus, they were also numbered lesser than the actual protesters. We're talking being seriously outnumbered.
You said that the security forces acted in self-defense. Were any of them injured by stones?
Yes, ma'am?
Were any of them injured by stones, by throwing?
Ma'am, there were no reports of injuries on the part of the security forces.
In addition to your defense that Ms. K. Lagomu did not order killing of the demonstrators, is it your case that the excessive force was not applied by the functionaries, the law enforcing agency?
Your Honor, in the given situation...
Or you say that the force was commensurate with the action of the demonstrators?
Your Honor, firstly, we're talking about 1,500 protesters in streets.
Yes.
If a normal column, because military is always, security forces, all forces always work in columns. If they're there in columns, they are flanked, and that is standard military procedure. If they are flanked, they have no option but to defend themselves. Now, if 1,500 protesters get to them, the chances of them coming out alive are very, very little. As was seen in Libya in the recent protests, government officials whose guards were overcome by the crowds ended up dying, initially even by stones. Blunt stones can cause a lot of head trauma. We're talking about security personnel who were not trained for this kind of thing. They're only there to maintain peace in a visual, perhaps even just a presence context. They were not there to riot control because there was no reason to be there for riot control. Riot control would only be a precedent when the last demonstration was violent, which was a larger demonstration. This time around, 1,500 protesters turned violent. Nobody expected it.
So members of the police functionaries or the armed forces were injured or in this story?
The proposition does not state any injuries on the part of the security forces. However, considering that armed forces shot and killed 120 protesters, considering that a standard weapon can fire up to 400 meters plus to 600 meters, they did have the advantage of range, which would have guaranteed them protection from the stones, not allowing the protesters to approach them in such a manner that they would come and kill them. But in order to make an effective range of protection, they would have to have fired shots, which may or may not have further aggravated the protesters. So the question of what the circumstances actually were would require a lot more details, which the proposition does not state in the given case.
Is it your case that all the protesters started throwing stones at the security forces when they were being approached by the security forces?
Your Honor, the proposition does not state whether all of them did or none of them, or very few of them did. They do not specify the number. But for the security forces, they do not have any form of identification of numbers. They cannot just tell from the front row of attackers as to whether the last row of attackers are also armed with stones or not, whether they too are carrying boulders or similar things that could bludgeon them to death. So they assume that if the front 5 rows, even if the 200 protesters had stones in their hands, they can't take the chance of trying to find out whether the last row of people also had stones or not.
I'm putting this question because you allege that they acted in self-defense.
Yes, ma'am.
They acted in self-defense. Nobody was injured. You don't know how many people threw stones. Again, still you acted in self-defense.
Because, Your Honor, their lives are under threat. They have this, the threat, which, if I point out to 31(1)(d) of the ICC statute, states of duress, which states that a person shall not be criminally responsible if the conduct has been caused by duress, as stated by Lord Edmund Davis in District Public Prosecutor for Northern Ireland versus Lynch, resulting from a threat of imminent death or of continuing or imminent serious bodily harm against that person or another person, and the person acts necessarily and reasonably to avoid that threat. Here, they're only armed with their guns because this was not riot protection police. They were not there to control a riot. They had no idea this would turn violent. They were only there to maintain the peace with physical presence only. So the only protection they have against 1,500 demonstrators, it could have been 700 that had stones, it could have been 1,000. They have no way to tell, but they have to defend themselves. It's either that or perhaps being lynched alive. They do not have the luxury of not taking a risk here. They are surrounded, they are in a situation, and they acted as what they thought at that given situation was the correct action. Furthermore, continuing with the defense of duress, I would like to state that in 31(1)(d), such a threat may be constituted by circumstances beyond a person's control, as seen in the prosecutor versus Adamovic. The ICC allows the defense of duress to include killing of civilians who are not innocent, as was seen in the prosecutor versus Adamovic, ICTY. The civilians targeted were not innocent, but were unlawful. They were breaking the law. Rioting is against the law of the state as well. Furthermore,
He breaks the law is not to kill him or them, only to punish them.
Absolutely, Your Honor, that is absolutely correct. But the given facts are that they were outnumbered by 1,500 protesters. They are security forces. They are not your regular police. They were not going in for a regular arrest. They were not going in with all the circumstantial information they needed. They were there for physical presence only.
Security forces were sane people. They should know that they are supposed to protect the civilians of their population.
Your Honor, that is absolutely correct.
They should not kill them.
They are supposed to protect the civilians. They are supposed to protect the general population. But in the event that the civilian becomes an unlawful civilian, that is, he attacks the security person himself, and he has no other option. He has men at his back, a whole column, maybe a platoon, maybe a brigade. He doesn't know. He has nowhere to run, and retreat is not an option unless a strict order is given. He cannot turn around and run. His life is threatened. He only has one solution: attack the attacker who's attacking him. He only has one means of doing that. There's no mention of riot gear. These are not riot police. They do not have the effective equipment required to deal with the situation. So they did what they could only do to protect themselves. They fired. And in context of the whole thing, they were being attacked by 1,500 protesters. The number of dead constitute about 8% of that, which in a standard situation, in a standard street, call it that of Champs-Élysées, which would only allow 400 people to stand flank by flank, which is only if they're organized. And these were protesters, so they were not organized. So the number of people killed stopped at 120 because at that point the crowds must have dispersed because they were being shot at when they were attacking an armed force which was bigger than they were, which was more heavily armed than they were, sorry. Furthermore, in response to the prosecution's accusation that six detainees in prison were deprived of food and medicine and were left into a situation where their lives was threatened, there's no evidence to suggest that these people belonging to opposite political parties were not provided with adequate food or medicine. Most NGOs, that is, on the credibility of the human rights cause, repeat anecdotal allegations from groups or individuals that reflect strong political agendas. Human rights call made unsubstantiated claims without public auditors and or independent individuals or groups responsible for verifying the accuracy of the report. Furthermore, there was no mass killing of a civilian population. The requirement here was, as seen in the prosecutor versus Tariq, that this needs to be of a collective nature. This needs to be systematic. There was no systematic or organized policy-driven attack on the population. This was a random event. The people who died were random people. They had no ties to a single either ethnicity or to a single political party. There is no proof whatsoever that determines that. Furthermore, the civilian population, as seen in Clark, Glynn, and Reagan on their book on the combatants and prisoners of wars, such civilians have been described as unlawful civilians or fighting civilians. In the present case, protesters, demonstrators always turned violent from this point onwards. The cases that I would like to refer to were stated in Antonio cases. Expert opinion of whether Israel's targeted killings of Palestinian terrorists was justified or not, where he states that when an overwhelming number of protesters or attackers that are not as heavily armed as a force attacks a force smaller in number, the force can use a fire against that group to protect themselves.
Excuse me, sir. You quote expert opinions before the court. Perhaps you should remind the court, what are the sources of international law? Are expert opinions a valuable or a credible or a legal source of international law?
Expert opinions do have a part in the sources of the international law because these people, they have expertise on the given situation. They understand the situation better than regular people, and they can contribute towards the better understanding for the court to understand whether the law would be applicable in the given situation. For example, unless you have a military commander who understands military doctrine and strategy, you cannot determine whether a civilian population working with or against or being fired upon a military can ever be given civilian protected status against a military force. You would require the expert opinion of the military commander. So he would be the expert person.
Okay. Are expert opinions a primary source of international law?
No, it is not.
A primary source of international law would be?
Would be treaties, cases, and legislation made in between states. Yes, sir.
Thank you.
Furthermore, in terminology of the attack directed against the people, which was supposedly systematic and organized, there is no such proof against it. These were random incidents, isolated incidents, and they had absolutely no connection or links to any government policy or actions or orders given by Ms. K. Legumu. Furthermore, I would like to state that there is absolutely no policy which is an essential element, as stated in Article 7.2a of the ICC statute, which limits crimes against humanity to multiple related acts forming an attack on a civilian population and to prevent isolated, uncoordinated, and random acts from being considered crimes against humanity in the present case. There is nothing that proves that what the government did was planned or a result of a government policy. On the second charge, Article... Yes.
What was the immediate reaction of Ms. K. Legumu after the incident? What was the immediate reaction of Ms. K. Legumu? Has that come on record?
Your Honor, Ms. K. Legumu had no immediate reaction as stated in the proposition.
Immediately after the incident, what was her reaction because she was the head of the state?
The head of state did not give immediate reaction, seeing as to how the whole incident is still not unresolved. There need to be investigations that will occur on the ground level. When they reach the president, then she can call in investigations on an independent state level. only then, once reports have been made, once she has been told what exactly happened, as the ground commander would tell her, once she finds out, only then can she actually take an action. Because so far, there's so much ambiguity as to actually what the protesters' motivation was, why did they turn violent, because the propositions has so far not stated anything in regard to that.
But she did support the action of the righteous way.
She said if the righteous wing's actions are peaceful, then the government has supported them. And if they are not, they will investigate whatever happens. And as far as the righteous wing having any tie to the government, those are pure allegations. There is no actual factual evidence to support the link between the government and the righteous wing. May I proceed, Your Honors? In the second charge of Ms. K. Lugumu, she pleads not guilty to the charge of committing war crimes of willful killing under Article 82A1 of the International Criminal Court statute. Now, the required elements require that the perpetrator has committed the actus reus of killing one or more persons, directly or indirectly. Now, the prosecution has so far failed to prove beyond a reasonable doubt that Ms. K. Lugumu had even stated or thought about the incident. There is no written evidence, there's no oral evidence, there was no express or implied order on the part of Ms. K. Lugumu. And in the case of any ambiguity, the definition of a crime shall be interpreted in favor of the person being prosecuted as stated in Article 66 of the ICC statute. Now, as to the reasonable doubt of the actus reus, Ms. K. Lugumu had no ill will towards the Kimon people. She even promised in her address to the people that she would address their problems once Rotavia came back to peace, something that Rotavia was finding it very hard to do with PFP and other opposition parties making this day-to-day life very difficult. They were creating a problem in maintaining peace. They were creating a problem in carrying out political activities or addressing the problems of the Kimon people. Now, she has never ordered her security forces on the Kimon people. There was no attack strategy, no policy, no suppression whatsoever. Now, there is, as a result, a reasonable doubt as to the actus reus on part of Ms. K. Lugumu, and she should be given the benefit of the doubt. Second element was that were these protected people? The question is, if civilians commit acts of hostilities, they not only lose their status as protected individuals, but they may become viable targets for the combat forces. Secondly, they may be tried in the courts for taking active part in the hostilities, as Manor and Mufid stated in the laws of armed conflict. Civilians actively or indirectly engaging in hostilities are regarded as unlawful combatants, according to Joran Deinstein, who wrote the Unlawful Combatancy book. And as a result, they can be prosecuted for the said actions. For example, in the event that even if they did take part in any conflict which did not exist here, even in that situation, including the given situation, they would lose their protected status under the Geneva Convention, which is stated in Article 5 of the Geneva Convention number 4, which states that thus includes those civilians who are suspected of taking part in hostilities from the protected status. As a result, the burden of proof here as to whether they were civilians lies on the prosecution, which has so far failed to prove that they were actually civilians. According to the norm reflected in Article 51(3) of the Additional Protocol 1, civilians who take direct part in hostilities, for such time as they take part in the hostilities, become legitimate objects of attack without enjoying the rights of civilians. So even in the given situation...
Sorry, excuse me, so there's just a passage you read there. For such time as they take direct part in hostilities. I stress, for such time.
Yes, Your Honor.
As soon as they cease to take direct participation in hostilities, then they retrieve their protected status and they cannot be targeted. You'll just have to explain to the court very carefully how at that moment at which they were targeted, they were clearly directly participating in hostilities.
I would like to bring to the court's attention the events that took place on the 20th and later on the 25th of August. Now, in the first incident, 3 security forces personnel were killed before anything could be done. They were attacked. We're not talking injuries. We're not talking broken bones. We're not talking grievous bodily harm. We're talking about straight-out deaths. And to kill a security personnel means that whatever you're holding is of enough deadliness that it caused his death. In this regard, military-grade weapons. And when the security forces retaliated, 11 people died. In the same time, in the same given time, a search operation resulted in 92 weapon-yielding people. These people had weapons on them within the locality. In the given situation, and then the second situation in which 153 people died after a standoff in a building, which was surrounded by the military forces and then fired upon, as a result of a bomb thrown at the security forces an hour earlier than the incident, and a bullet fired at the security personnel. In both cases, any unlawful combatant present at the given situation, as long as he's partaking in hostilities, which means he has a violent factor, he can cause harm to the security personnel. He is a legitimate target.
So that's not the legal test. If he has a violent factor, is not the legal test. The legal test is he, at that time, directly participating in hostilities? If I could just for one more sentence, and then we'll continue, please.
Your Honor, what I was referring to, is he a violent factor, means that if there's violence going on, is he a factor of the overall situation? Is he adding to the violence in the situation, which means, is he partaking in the hostilities? That is what I was referring to. I wasn't saying that he is capable of violence. I was saying he is a violent factor. There's an overall situation, he's a factor of that violence. The moment, I'll finish the answer, Your Honor. The moment he puts down his arms, now he's given Geneva Convention's protection once more. He is now a surrendering combatant. He is no longer a viable target to attack, and that was accepted by the government. Now, I'll just finish very quickly here. The civilians who were killed by the security forces on the 20th of August and 25th of August confronted the security forces with firing and the throwing of a bomb. Furthermore, weapons were recovered from both localities, first from the search operations in the Qibla location, and secondly from the SIL headquarters. Now, these alleged civilians did partake in the hostilities. Thus, they were viable targets by the security forces at the given incident. Lastly, I would like to talk about the Sapala status as an independent state. Before I get to that, one last thing I would like to state in the given situation is that for this to have been an armed conflict, certain things would have been required, like a proper military functioning in the area, a group or functionality that looks or resembles a military force, has the funding or the resources that a military force does, and can do sustained military operations, which the SIL could never do. Furthermore, Article 1, Section 2 of the Additional Protocol 2 also distinguishes armed conflict from internal disturbances and tensions. And this was an internal disturbance in the state of Batavia and not an armed conflict. Furthermore, any and all armed incidents that took place before the 25th August attacks were carried out by armed groups or maybe criminals. Nobody knows because nobody took responsibility. The SIL never created a link between themselves and the armed hostilities. The requirement for state recognition is that it is of an international nature, that states within and around the newly alleged state accept its existence. As was seen in the SZABIST case, the International Criminal Tribunal for Yugoslavia held that the conflict within the former Yugoslavia was only of an international nature after international recognition of the independent statehood of Croatia, Bosnia, and Herzegovina was declared. But so far, nobody within the region has accepted the statehood of Spala. As a result, Spala is not an independent state. Furthermore, the people of Spala are not being represented by the SIL. There has been no outcry from anyone stating that these people represent us, nor has SIL ever been in the government of Spala, either on a provincial level or on a state level, as representing the people of Spala or the Cuman ethnicity as such. Thank you, Your Honor.
Counsel, you may proceed with the rebuttal.
Your Excellencies, if I may. Thank you. First of all, Your Excellencies, I would like to address the issue of proportionality. That is, in the case of the crime against humanity of extermination, on the day of the 22nd of June 2010, when 120 demonstrators were shot on by security forces and 120 were killed, Was this action by the security forces a reasonable and a proportionate reaction to the demonstrators? For this, I would like to refer to Article 31 of the Rome Statute of the International Criminal Court. Your Excellency, the defense of self-defense is only available to those individuals who act reasonably to defend themselves in the face of an imminent and unlawful use of force in a manner proportionate to the degree of danger to that person. In this case, Your Excellencies, there are a few facts which must be taken into account. First of all, the demonstrators were armed with only stones. Second of all, they threw the stones while running away. This means, Your Excellencies, that the security forces, if their aim had been merely to disperse the crowd, the security forces reached the area where there was a disturbance, managed to disperse the crowd because the facts prove that the demonstrators were already running away before they started throwing stones. So they managed to disperse the crowd, and only after they dispersed the crowd did they decide to shoot on the protesters. Your Excellencies, were the civilians who were carrying merely stones while running away such a threat, such an imminent and unlawful threat to security forces that they could think of taking no other action except to shoot upon the crowd? Your Excellency, it is humbly submitted that these specific criteria of Article 31 are not fulfilled according to the facts of the case. Secondly, Your Excellencies, it was contended by our honorable opponents that a subordinate's illegal acts are not the responsibility of a superior. This means, Your Excellency, that heads of states, or any superiors for that matter, have no responsibility for the activities of their subordinates. This seems to go against all forms of law and case law and legislation that we have been through today. In fact, Your Excellencies, if I may refer you to, Article 28A of the Rome Statute of the International Criminal Court. This refers to the superior responsibility of military commanders or any persons acting as military commanders. In this case, Your Excellencies, even if the court does not consider Ms. K. Legumo to be a de facto military commander, the fact of the matter is that under emergency provisions, she had control over all aspects of government, executive and military, as emphasized earlier. Therefore, while she may not be a de facto military commander, she was acting as a military commander. She had the powers of military commander and therefore satisfies the criteria of Article 28A. And therefore, if she knew or had reasonable reason to know, according to the circumstances at that time, that the security forces were going to commit a crime or had committed a crime, if these criteria are filled, Your Excellency, she was responsible for the acts. And it is humbly submitted before this honorable court that that the circumstances at the time, the circumstances were that the opposition had increasingly been resorting to violence. This was a circumstance that Ms. K. Legumo was aware of. This was not a circumstance that she could be said to be unaware of. Since she was aware of this, even though it is humbly submitted that she may not have ordered the killings directly, her failure to take steps to prevent the killings from happening, or her failure to make orders to ensure that the killings did not happen, knowing that the protesters may resort to violence, this is a failure which we are humbly submitting she may be held responsible under. Further, Your Excellencies, the element of actual knowledge. Did she have actual knowledge of the crimes? It is humbly submitted, indeed she did. Your Excellencies, while it is submitted by our honorable opponents that Babylon Times was not a reliable source, this was just one of the sources. What about the sources of the Human Rights Call? What about their allegations? They were a reliable source. They were relied on for other pieces of information as well, such as the number of prison detainees. Why not be relied on for the number of deaths that have taken place? What about the foreign media who specifically alleged that it was rightist wing who was carrying out these crimes? Even if the court considers that Babylon Times was not a reliable source, this was merely one source out of many, Your Excellencies, and all evidence must be taken into account before His Honorable Court comes to a decision.
Excuse me, but the knowledge of crime does not mean that she is connected with the crime.
Indeed not, Your Excellencies. However, under the Article 28A, she, being a military commander or having the powers of a military commander, that is acting as a military commander, under this article, she may be held responsible for the acts of subordinates, even though she did not directly commit them herself.
Really on the question of knowledge?
Yes.
The crime has been committed.
When a crime has been committed and there is a superior subordinate relationship established, and the perpetrator knew or had reason to know, according to the circumstances, that a crime would be committed or had been committed, when all these elements are taken into account collectively and they're all fulfilled, yes, then she may be held liable for the acts of those other than herself. Your Excellencies, further on, what about the fact, the allegation made by the opponent counsel that the Human Rights Court is making sensationalist claims? Were they sensationalist claims? And if they were the people who were killed part of a targeted population? Indeed, Your Excellencies, even if we only take into account the 6 prison detainees who were killed, even just taking into those people into account, it is humbly submitted that what our honorable opponents failed to recognize was that those 6 killed detainees were members of the PFP, as were every other member of every other victim who was killed were also members of the PFP. As emphasized earlier, Your Excellencies, this could not possibly be a coincidence and seems to imply that this was a continuation of the defendants' policy from the very beginning of repressing or suppressing any form of dissent to the government. Your Excellencies, if I may move on to the charge of the war crime of willful killing. In this case, the question as put forward by honorable opponent was that was Ms. K. Lugumo's regime a racist regime? And it was humbly submitted by them that it was not. However, in this case, I would like to emphasize that it was a racist regime because the sentiment of the people of the Kimon ethnicity was not merely a sentiment of a people. It was not merely a feeling of the masses. This was a sentiment that was even expressed. And I say this because there was an electoral process held, and there were people of the Kimon ethnicity who won seats on the basis of the issue of Spala secession, of a secession of Spala. So, Your Excellencies, I would humbly like to submit before the Honorable Court that this expression of sentiment in a way that the President of the country would definitely have known about fulfills the requirement that it was a racist regime. If Your Excellencies have no further questions, I would submit. Thank you.
Defense Counsel, you may now proceed with the rebuttal.
Your Honours, in response to the prosecution's first argument, which was that of the use of force being reasonable according to the Rome Statute, here's the biggest problem. How do you define reasonable at the given situation? It is defined as what a reasonable man would do in the given situation. What would a reasonable man do when all you have is a weapon and you're being attacked by an overpowering number of people who are attacking you? Regardless of whether they're using stones or if they're using canes, both can prove deadly. What would a reasonable man do? He can't run, he is cornered. He has men behind him who will not move until the last man moves. He is under attack. It's a split-second decision. What would a reasonable man do? Would he stand and die? Or would he use the defense of self-defense? And he would pick that weapon up, shoot the man nearest who's about to throw a stone at his face. The question is, what would a reasonable man do? I say a reasonable man would do exactly what the security forces did. Secondly, the prosecution states that they were running away while they were stoning them. In the military, they speak of this tactic called revolting. It is what tanks do when they turn around but keep the turret pointed towards the enemy, firing at the enemy, coming to a distance, and then retaking the position until the enemy reaches them. This way, keeping out of the enemy's reach while attacking them continuously. This does not take a lot of strategy to formulate. This is a simple, common, logical sense argument that any man using a stone would do. I see a person, I throw a stone at him. Until I find another stone, I will run away. But I will come back with another stone. The crowds did not disperse. If they dispersed at the first shot, there would be no 120 kills. They would be gone. They would fire twice in the air. Everyone would run away. They did not run away. As a result, 120 people did die because they were attacking continuously. Thirdly, we never said that the head of state was not responsible for a subordinate's actions. We stated that when and only when it is proved that the subordinate did an illegal thing, the head of state would be responsible. And only then, if he or she does not take an action with the knowledge in hand. Furthermore, if you look at preposition 3, preposition fact number 3, you would realize that it states that Ms. K. Lugumu had control over almost all aspects of government, not all aspects of government. The prosecution misstated the fact there. Furthermore, as far as the awareness goes, she was aware of what occurred after it had occurred. Because if she was aware before of it, she would have known about it. And then this would have been a mens rea for an action that she had done in violation of the war crimes. This never happened. She found out only after it had happened because there was no prior planning. Furthermore, the second source they're quoting is a human rights group that has no credibility within the state, that has no credibility internationally, it has no public auditors, it has no independent resources confirming its authenticity. And as far as HRC being a source goes, HRC reports to the media. HRC itself is not a media group, whereas Babylon Times is a media group, and their message does reach the people. And then the reliability of the Babylon Times itself. Are they reliable? There's just one media group. And foreign media, there may be states around Ratavia who want Ratavia to break. They want Ratavia to have issues so that once Sapala is broken away, because if you look at the map, you will see Sapala is a large tract of land with only 5 million people. This is very, very prime property for eventual occupation maybe. This may be spy activity, espionage by a third state that nobody knows about. There are so many possibilities which create so many doubts as to whether this was actually pre-planned or not. Furthermore, the prosecution states that Ms. K. Lugumu was acting as a military commander. The question is, what defines acting as a military commander? Does she make all the military decisions? No, Your Honors. President Obama doesn't make all military decisions. The President of the United States cannot fire a nuclear missile without the verification of a second person in his cabinet. A military commander is also limited in his use of force. He needs to act with the help of his subordinates. In terms of acting as a military commander, Ms. K. Lugumu cannot act until and unless a military advisor is there. She may be the final version, but she is not a military personnel. She is still a civilian leader. And the military personnel would only be present with her in the event that this became an armed conflict where the government was sitting in a war council. And as far as the 6 detainees all belonging to PFP, proving that this was against a specific group of people, they have again misquoted the facts. The preposition states that they were PFP and other parties. These were detainees from different parties. This was not just against the PFP. This was a lot of people who had been detained on orders. And they were detainees who acted in violence against the prison authorities. And the prison authorities did what a prison authority is supposed to do. They stopped the confrontation. However, the 6 detainees did die in that confrontation, but that is not something new. That occurs all over the place because these people were violent. That is the reason they have been detained. Out of the thousands of protesters, a few are detained. Those few are the ones who are calling for violence. And if you look at the preposition, we see that Mr. Ermas, in his statement, told the protesters to do whatever they can to overthrow the government. Whatever they can did not include whatever they legally can. And lastly, with the question of Sapala, I think we already established that Sapala was not an independent state. And for them to have incurred the international armed conflict rules, they would first have to prove that it was a state itself, which it never was.
No, I'm not sure that that's quite the case, sir. I believe, if I understand the prosecution's argument correctly, that they were not contending that Spala was an independent state in and of its own right. And I draw your attention particularly to the Montevideo Convention Article 1 for determining when a state does not exist. The issue at hand, I think they were suggesting, was one of possibly two things, Article 1.4 of the First Additional Protocol, or they may have mentioned overall control in accordance with the test established by the Tadic decision. So perhaps just to finish, you could address those questions
I'll just
specifically.
Answer this, and the point I was making was, the prosecution stated that these people were a race, that the government was racist, that we were going towards the genocide argument, which isn't even the charges.
No, so I think the term racism to which they referred has nothing to do with genocide. It, in fact, is just a technical legal term in Article 1.4 of the First Additional Protocol.
In that context, I'll take it in that context, and I'll answer in that context, sir. In the given problem, the government is not racist. At no given point has any legal policy been adopted that would target the Cameroon people. There have been no military actions against the Cameroon people. There have been no deployment of military forces against the Cameroon people. Even there has not even been a curfew established in Paradise City. This is the extent to which the government is not racist. In terms of what I was earlier saying, Sapala was never a part of the problem. Sapala had a problem in terms of the SIL acting illegally. We're not talking about an independent state that has an independent military finding the independent military of Ratavia, which would constitute international armed conflict, which would eventually totally disprove the prosecution's last argument. Thank you. Thank you.
The court is now adjourned.
Honorable judges, esteemed faculty members, dignitaries, participants, and dear guests. I am Sharbano Rizvi, member of the Organizing Committee, Hospitality Department, and I will be your host today. Good evening and welcome to the closing ceremony of the SZABIST International Humanitarian Law Moot Court Competition 2012. May I please request all of you to rise for the national anthem and please sing along. The 14th of January dawned with intense competitions amongst teams from all over Pakistan, and today, the 15th of January, marks the end of it. From moot courts to dinners, from excitement to disappointments, this experience has been invaluable. As this rich venue with culture, I shall share with you a verse by Allama Iqbal that describes the organizers' sentiments. Tundiye baade mukhalif se na ghabra e oqab, wo to chalti hai tujhe uncha udane ke liye. Crudely translated, this means we must not be frightened by the strong cross winds, O falcon, since they blow to make us fly higher. I will now begin with the program. May I please request Mr. Asif Hussain, Head of Academics of the Organizing Committee, to come and share a few words with us.
Thank you very much. I'd like to welcome the Chief Guest, Justice Faisal Arab, and the Guest of Honors to our closing ceremony of the SZABIST IHL Moot Court Competition 2012. Our journey with International Humanitarian Law began 4 months ago with 3 loyal friends and 1 very encouraging teacher. Our hopes were bleak and our ambitions were beyond our usual standards. But we did it and gave you the first ever All-Pakistan International Humanitarian Law Moot Court Competition. Initially, we were selected to represent Pakistan by the ICRC in the Henry Dunant South Asian Regional Round in Nepal, and we brought home a determination to give back what we learned. This is the culmination of months of hard work and dedication. We're grateful that the participating institutes could help make it a success. We needed your enthusiasm to promote this cause, and you did not disappoint us, traveling in excess of 27 hours of bus rides in cruel weather and neglecting your studies so that you could survive 2 days of intense mooting. Give yourself a big hand, guys. You've done a great job. The field of IHL suffers in Pakistan despite its relevance in the contemporary issues that are a cause of Pakistan's instability. Like us, we hope that after this experience, you too will have the capability and yearning to see the world around us in light of international humanitarian law. Who better to judge us in this endeavor than the honorable and esteemed judges who have truly made us feel worthy by showing support in this event, and we never dreamed we could have associated with the judges of your caliber. I will recall the tense calls I made to The Hague, Rwanda, New York, only to locate Justice Khalda Rashid Khan in Tanzania and request her to come and judge us in this moot court competition. I will also... how we made frantic calls to the Research Society of International Law in Lahore and tried to gain the sympathy of Emir Bilal Sufi Saab by reminding him that our very own Sir Nasser once interned with him. And Mr. David Tuck, who has become, in a very short period of time, a good friend of the organization committee and whose enthusiasm and energy has been limitless in helping us and supporting us. We hope to have gained from all of your wisdom and to receive your blessings in promoting IHL. Now, lastly, I would like to thank FM 89 for helping us publicize this event, the first of its kind, and we really needed the publicity in order to promote this cause. Thank you to them. Ms. Shaista Sarki, who has allowed us to become the host we are today, and that is left for you to judge if we did satisfy you. We can't thank the judges alone enough for their contribution in this event, so I'd like for you to give them another round of applause. The brave volunteers who suffered under my authority. Please give them a round of applause. And most importantly, to you, the participants who had the courage to do something new and help this to become a success. Please. Now, with that, I would like to invite you. Thank you very much.
I would now like to invite Mr. Nasser Ahmed, the chairman of the organizing committee, to express his gratitude.
We are greatly honored and privileged to have Honorable Justice Faisal Arab with us today. Sir, really thank you for coming. We really appreciate your presence. I also wish to thank Judge Khalda Rashid Khan. I just found out that all this while she thought I was a student. Ma'am, I'm very flattered. I'm very flattered you made my day. Thank you. On a serious note, I wish to thank a few people and organizations which have made this event possible. The ICRC, without whom this event would absolutely not have been possible. Please give a big round of applause to the International Committee of the Red Cross. I wish to particularly thank Mr. David Tuck for having faith in us when no one else did. David, I sincerely would like to thank you for your encouragement and your support throughout. Thank you. For all the teams that have come from as far as Peshawar and have undertaken 20-hour-plus journeys, you have made this event what it is. And I hope the experience was worth all your efforts. And I also hope we did not let you down with our hospitality. Thank you. I also wish to particularly thank each judge by his or her name, especially because they have been sitting through long moot courts. I know David sat through 11 moot courts of prosecutor versus K. Legumo in 2 days. That is quite a lot. I'd like to thank again Honorable Justice Faisal Arab. He was kind enough to give us an appointment. We went to his office and he agreed to come, and we are really grateful to you, sir. Extremely honored and lucky to have one of the most prominent IHL personalities of Pakistan. Ma'am Khalda is the President of the United Nations International Criminal Tribunal for Rwanda. I think no other Pakistani has had that honor before. Ma'am, we are proud of you, and we can't thank you enough for coming. Thank you so much. David, I've already thanked. Sandra Tetamanti has been a judge for the preliminary rounds. Mr. Saqib Jilani, who flew all the way from Oman. Mr. Nasir Jalil and Mr. Dilawar Khan, who were kind enough to be encouraging throughout the event. They came all the way from Islamabad. Barrister Shahida Jamil was the judge in the preliminary round. And of course, Mr. Ahmed Bilal Sufi, who had to leave early today. But we really appreciate him just flying out for the day from Lahore and being a judge for the better half of this event. Last but not the least, there are 12 people I wish to thank. Some of them were here all night yesterday. There was no electricity at Frere Hall. They were here all night preparing for this event. They did not say no to any task that was given to them. They worked for this event, much to the displeasure of their parents who missed them and didn't see them for days. Without these 12 people, them running around Karachi to pick people up from airports, bus stations, or getting stuff printed, or picking up, dropping the judges, this event is dedicated to the 12 members of the organizing committee. May I please call on stage for a very quick round of applause, Zulekha. Zaim Haider, Asif Hussain, Alisha Ansari, Nahal Chamdia, Shehrbano Rizvi, Sara Zia Khan, Amina, Hamza, Murtaza, Fahad, and Taimur. Please give them a huge round of applause. Thank you so much, the organizing committee. Thank you so much. Please have your seats. Also, the volunteers who acted as court clerks and timekeepers, or hospitality coordinators, ushers, or even a stand-in audience when we needed to fill up the hall. Thank you. We owe you the smooth completion of this event. The last remark that I wish to make is that the reason for organizing this event was to make sure that we had a wish, basically. We had a wish that a team of Pakistani law students should win the prestigious Henri Dunant or other similar international or regional moot court competitions. Only time will be a judge of whether we achieve our wish or not. But as they say, we should never underestimate the importance of small beginnings. And in the meanwhile, we hope that this event will kickstart an era where Pakistani law students will get more opportunity to participate in moot court competitions, particularly IHL moot competitions. Thank you so much.
Ma'am Shaista Sarki, if you please could say some few words.
It's a privilege and a great joy for me to extend a vote of thanks to all those who have contributed in one way or the other to make this event, this moot court competition, a huge success. I sincerely appreciate the hard work and dedicated efforts of the office bearers and the co-organizing committee of the SZABIST Law Society under the guidance of Nasser Ahmed, who had been a driving force behind this whole process. His vision, interest, and hard work has culminated in a success story. Nasser, you deserve congratulations on a job very well done. I wish to thank ICRC for their assistance and acknowledge the support rendered by them, particularly by Mr. David Tuck. The honorable guests have brought here with them and shared with us their knowledge and experiences. You have guided us in the right direction, and we appreciate you. We understand that you have taken time out of your very important schedules to contribute to this moot court competition, and some of you have even traveled at a very short notice. Thank you very much for your invaluable contributions. I also wish to thank the students who have attended this moot. The interest and enthusiasm you have shown is indeed a good sign for the future. Before concluding, let me express our sincere gratitude and appreciation to the guest of honor Judge Khalida Rashid Khan. My sincere thanks to Honorable Justice Faisal Arab of the High Court of Sindh for being a chief guest at this closing ceremony. They have raised the occasion with their presence. Thank you so much.
Mr. David Tuck, if you could just express your overall experience of the two-day rigorous judging process at this International Humanitarian Moot Court competition.
Sure, thank you. Look, if I could just say a few words for a few moments. It's true, in fact, that I've sat through 11 moots on the same facts. If anybody mentions Legomu's name in the next few days, I will kill them. But you may have noticed by the end, certainly by the last moot, that I had run out of intelligent questions. I apologise to UCL for asking the very basic question of what are the sources of international law. That reflects the fact that simply the standard and the calibre of the mooting was fantastic to begin with, and as the day and a half or 2 days that we've been through progressed so far, and the teams, of course, learnt new arguments and developed new ways of presenting them, that simply by the end, I had run out of ideas. I believe the presentations that we heard in the final, as well as many of the presentations we heard before there, were absolutely fantastic. And fantastic given the fact that many of the universities are not exposed to international criminal law and not exposed to humanitarian law in their regular course of events. So it's a little bit sad, in fact, that it's come to an end. I'd like to, even though it's been said a number of times, express my thanks very, very quickly. Certainly it has been said, but there's a reason that we must thank a number of people for an event like this. It requires an immense amount of work. It requires an immense amount of individuals' time. So, as has been mentioned a number of times, I'd like to thank first and foremost the judges and our honourable guests who have taken time from their very tight schedules to be in attendance today. It's a real honour to have such incredible personalities with amazing experience in the field to contribute to this. Second, I would like to thank the coaches and teams. It's been said again, but it's no small thing that coaches and teams have travelled from as far away as Quetta and Peshawar at their own expense to be here for the weekend. It shows great commitment, great enthusiasm. Thank you. I would also, of course, like to thank the organising committee who have put in an immense amount of work. I was reflecting just the other day that I had read an article which said that one of the scariest things that humanity has learnt in the last 10 years is how effective sleep deprivation can be as a method of torture. And for all of our talk about the rights of people and human dignity over the last 2 days, the SZABIST organising committee have been operating now for a few weeks on about 2 hours of sleep a night. So we apologise for that gross violation of your rights. Thank you very much, though, for your assistance. I would just like to touch on one area of substance because it came up again and again. And in fact, I think the Moot Court teams addressed it very well. The question is, in an international armed conflict, or rather in a proxy war, can the people deprived of their liberty be said to be non-nationals of the people who are holding them in accordance with Article 4 of the 4th Geneva Convention? Now, many of you rightly, correctly said, listen, it's logical. If we have a proxy conflict, the people who have been deprived of liberty must be protected. What I was pushing for a little bit further was that this area of the law has in fact been developed by, of course, the Tadic case, which has developed many areas of the law, and I was just pushing for that area or for that legal citation in which the Tadic case said that on the basis of allegiance rather than nationality, we can consider them to be protected. So I just wanted to mention that one point. Finally, from my side, we will, inshallah, hold a moot court in the middle of the year to select the team for the Honorary Do Not Moot Court competition, which in turn will actually be at the end of the year. I leave it to the discretion of the coaches and universities to choose the best team, but my impression from this weekend is that the best teams have already been chosen. We hope to see you all again in the middle of the year. So from my side, if I could just thank you once again for a fantastic competition. Thank you.
Judge Khalda Rashid Khan, would you like to say a few words to share your experience? Yes. Would you like to say a few words? You can just stay there. You want to say something?
Honorable judges of this competition, respected guests, and dear students, it's a great honor for me to have opportunity to briefly address you in this evening. I would like to thank the SZABIST Law Society for inviting me to be a judge in the 2012 International Humanitarian Law Moot Court competition. It is always a pleasure for me to be among great minds, such as student participants, judges, and organizers of this competition. You, the students in this competition, are the future of international law. Your involvement in moot court competitions such as this one is crucially important to developing the skills necessary to effectively practice law anywhere in the world. Your hard work in the competition and the knowledge and the skills that you gain here, therefore, will have an impact not on your own future, but it will help you, inshallah, to be a part of ensuring that profession of law retains its current high standards for many years to come. Working in the International Tribunal has provided me with an opportunity to see how important international humanitarian law is to the world today. In Pakistan, as well as anywhere in the world, where armed conflict continues to plague the peaceful life of the civil population, the work of the lawyers, human rights activists, and you, future lawyers, have become all the more important and helps to limit the effects of armed conflict for humanitarian reasons by protecting the victims. At the end, my speech is not very long, it's a very brief speech, few words. We all know that we are very tired, so at the end I would like to congratulate the participants and also the winners of this competition. My special congratulations to the organizers of today's event. I wish you all the very best in your future endeavors. Thank you all.
Thank you, ma'am. Now we will proceed to the prize distribution. May I please call Zulekha Sakarani to distribute the certificates of participation to all the 12 teams. I will request all the 12 teams to please come up front so that we can proceed.
Thank you, Sharbano. Good evening, everyone. May I please invite Mr. David Tuck to come and give out the certificates of participation? Thank you, David. First, we have the students from LUMS, Shamaila Khan and Shehzad Ghayas. Are they here? No? Okay. Likol, Fawad Baloch. No? Okay, Likol's not here? Okay. Fawad Baloch, Bilal Channa, and Jeena. Then we move on to University College Lahore. Chaudhry Muhammad Ali.
Hamza Haider, Muneeb Tariq, Law College, University of Peshawar, are we here? Ali Gohar, Fahad Bashir, Anwar Shamim. Is Stills here? Okay. Hassan Ghuman, are they here? Are they with us? Okay, we'll move on to Pakistan College of Law. Faraz Nazir, Shehbaz Sandhu, Sarib Ikhlaq, okay, so SZABIST, Hiba Thabani, Faiza Salim, and Mishal Lakhani. Faiza and Mishal. Okay. Can we now have University Law College, Quetta? Munir Hussain. Is anyone here? Okay. Muhammad Ali Kanrani and Muhammad Daud Jan. Okay. Is Bayview High here? No. Okay, but there were Khadija Shakil, Sumaya Sarwana, and Aisha Iqbal. Any representatives from Bayview? No. Okay. City School of Law, Quetta. Arbab Gulzareen. Ramzan Ali. And Bilal Jogzai. Now we have Qaid-e-Azam Law College. Arsalan Ghaus. Azam Siddiqui. And Zara Zafar. Next we have Gilani Law College. Farah Javed. Muhammad Mohsin Sana. And last but not the least, Qudsiya Razak. Okay, I will now proceed to the awards. Mr. David, can you please give those out as well?
Sure. The prize for the best individual mooter. So it's the mooter from amongst the teams who was able to articulate, we thought, the judges thought, most clearly. The mooter from amongst the teams who was able to consistently present the law in the most clear and presentable manner. And the winner of the best mooter is Hiba Thabani from SZABIST. Congratulations, well done. Now we have another individual prize in many ways. And you'll have to forgive me, I don't have the name of the winner. But the prize is for the best researcher. And the best researcher, as I understand, was judged in part on the research component of course, the memorial, but in part on the participation of the researcher during the moot courts. Because, of course, the moot court is not simply the two people who are presenting, but there is always somebody in the background who's involved. And we thought it was very important to recognise this person because this person always, in many ways, holds together the argument. So without any further ado, I'd like to present this award to the researcher from QLC. Congratulations. Okay, and last but not least, we have an award which is rather more of a team award. You know that you all wrote memorials, prosecution and defence before you attended this. The ones at least that I read I only read 6, I have to confess, but were very, very well written. And the award for Best Memorial goes to QLC.
Now I would like Ma'am Shaista Sarki to please present the judges' shields. Mr. Saqib Julani. Mr. David Tuck. Mr. Dilawar Khan. Barrister Shahida Jamil. Okay, she's not around. Mr. Nasir Jalil. Judge Khalda Rashid Khan. Sorry, ma'am, we have to have you off stage after 2 minutes. Miss Sandra Tatamonte. And lastly, Justice Faisal Arab. I would now like Mr. David Tuck to please come back and announce the prizes for the runners-up and the winners.
Ladies and gentlemen, may I invite Mr. Justice Faisal Arab to come down and present the prizes, please. Now, ladies and gentlemen, after 2 days of intense mooting, it all came down to approximately 50 minutes in the final. 50 minutes well argued, arguments very well refined by this stage. Both teams performed extremely well, as in fact I should say both teams had been performing extremely well since the very beginning. Now, on the basis of the final 3 judges' decision, I can announce that the runner-up with a mark of 450, of 299 is QCL. And of course, the surprise has been given away. With a mark out of 450 of 339, of course, it's SZABIST Karachi.
I would like to say a few words on behalf of my team, and I believe I'm also speaking on behalf of SZABIST as I say this. It has been a taxing, emotionally and physically journey for my team members and I. And it was difficult, but we pulled it off after many sleepless nights. And right now, I'm humbled to be able to stand before you and to see all these wonderful teams that we competed against. And I know it sounds like I'm boasting, but yes, we won. However, in our personal conversations with our opposing team in the final round of the competition, QLC, they told us something that astounded me. The junior counsel, Mooter 2, told me that this was the first time, told me and my team members that this was the first time that he and his team members have ever mooted. And despite that fact, it is before all of you. You can see where they are. And I think that my team members also agree with me when I say that they deserve this trophy and not us. And we would like to present it to them right now.
This was actually our first time mooting, and quite frankly, we were thinking, when we go back, we'd show them that we attended it. So this was unexpected. Being in the finals was unexpected, but all in all, it's a little hard for us to explain this because this was overwhelming. You people were overwhelming. The judges were overwhelming. I met people that I didn't think I could. They were that far above. And when you meet them and you realize how much they've learned in their lives and how much experience they're giving us, that's when you realize, this was a once-in-a-lifetime opportunity that, we got. And and from the moment we got off the train, a miserable train, by the way, but the moment we got off, from then till now, SZABIST has been wonderful. They were actually beyond wonderful. And even now, although we will go for trial, even now, this was more than unexpected. And I actually don't know what to say, except that this was by far the realization for me as to why I wanted to be a lawyer. It was here that I realized why I chose this profession. And it's because of people like you. You're all amazing, wonderful people. People I am living with in the hotel, people I'm mooting with every day, and also the people who are teaching me something new every day and pushing me to my limit, pushing my teammates to their limits, and the rest of us to our limits. Yes, sir, sleeping deprivation is torture. But I just want to thank you all. Thank you so, so very much.
Now I would like Honorable Justice Faisal Arab to please say a few words so we end the ceremony.
Mr. Justice Khalda Rashid Khan, Mr. David Tuck, Mrs. Aisha Sarki, Mr. Nasser Ahmed, the organizers of this competition, ladies and gentlemen. It's been a great pleasure to be here and be part of the mooting competition participated by 13 law schools of this country. The enthusiasm and the spark that I witnessed in the competitors today was remarkable. It was only the overall impact of the performance of the winning team that caught the imagination of the judges. Otherwise, the losing team has equally displayed excellent advocacy skills. Mr. Fakhruddin Ji Ibrahim was my mentor. I worked for him for 12 years. One day I asked him what it takes to be a good lawyer, and he said all it takes is hard work and passion for law. He told me that one does not have to be extraordinarily brilliant. These words were quite heartening for me, as I was not a brilliant student of law. His words got printed on my mind and were of tremendous help in achieving the success that I gained in legal profession. When you will start practicing law, one thing you must not forget: there would be scores of adjournments before your case is finally decided. Don't get bored with the preparation of your case each time when your case comes up for hearing, because each time when you will be going through your brief, you might notice that you are better prepared this time. You might have missed out on some important aspect of case earlier, which was important for your client's success. This passion for law would always force you to be well prepared every time. It is this hard work and passion that my mentor, Mr. Fakhruddin Ji Ibrahim, was referring to. My advice to law students is to take advantage of the past experiences of others. Hard work and passion is the key to success. If you do not have such traits, then no matter how brilliant you are, you will not succeed. One day on a dinner table, I was sharing my past experiences with my son. When conversation ended, and after an hour or so, I asked my son, did the discussion interest you, or you simply got bored? And he replied, Baba, the greatest advantage of the next generation is that it gets to know about past experiences of its earlier generation for free. The past generation of this country had already experimented too much, be it the forms of government or the judicial system. Before the present generation lie the experiences of the past generation for free, so that it may take this country to the right direction. This can be achieved if you take advantage of past experiences and keep on doing whatever you do, doing with honesty, backed by hard work and passion. I must congratulate the office bearers of SZABIST Law Society in organizing this wonderful competition, which have put in such an excellent effort to make this occasion a success. I thank you for inviting me to participate.
Thank you, ladies and gentlemen. This is the end of the closing ceremony. Thank you so much.